It's my very great pleasure to be joining you for this Data Protection Congress. Many of the presentations will focus on Spanish data protection law. I hope that my presentation will complement that by looking at a topical issue which confronts Spanish data protection as well as EU data protection more generally. And that's the evolving relationship between the EU regime and the UK data protection regime, given that Brexit has now become a reality. And in particular, I want to investigate whether that relationship will look like the Swiss relationship with the EU, which on data protection is the closest, other than, of course, Iceland, Liechtenstein and Norway, which through the European Economic Area are essentially fused to much of the EU data protection framework. So, discussion on the framework was an important part of the Brexit negotiations, and that reflects the importance of personal data and personal data flow, both to public sector projects and, of course, to the development of online and the private sector more generally. The December 2020 Trade and Cooperation Agreement sets out the framework, and I argue that it essentially produces a dualistic approach to the issue. On the one hand, we have the area of what really is mainly about crime, but often goes under the language of justice and security, where there's extensive provision for a very broad exchange of very sensitive data often, but based on commonly agreed and specified standards. Otherwise, the agreement adopts a much looser perspective. It's really based on a mutual adequacy, or moving towards mutual adequacy, where each regime recognizes the other as adequate for the flow of personal data. But this comes with significant discretion in principle as regards how those two regimes may evolve in the future. And very tentatively, I want to explore that in this presentation as well. I want to explore that because that gets to the issue of the comparison with Switzerland. At this very high level, the UK and Switzerland look very similar in terms of their relationship with the EU. But I argue that Swiss data protection norms are more stably consistent with common EU data protection norms than the UK. The UK has a history of a more sceptical attitude to some of the EU's understandings, and with that, in the medium term, may come more divergence and potentially even some more tensions. Okay, so let's first turn to the very important and quite surprising provisions on the exchange of justice and security data. DNA, fingerprint, and vehicle registration exchange are all provided for, and that is sometimes put under language of PRUM data because it comes even within the EU from a convention, the PRUM Convention, which was agreed by a number of European Union countries and has since been expanded. Quite a lot of the cooperation is even within the EU quite new, and so it's striking that this will continue with the UK. There's also provision for a passenger name record exchange of data. Again, quite unusual in terms of how many agreements the EU has with other third countries. And for more diffuse exchange between the UK and bodies like Europol and Eurojust. The significant omissions here have to do with Schengen. The Schengen Information System and also the system for immigration documentation, Eurodac. But these, and of course Switzerland does have access to both these systems and is even involved in their management. But this divergence, I think, has more to do with the fact that the UK has chosen to leave freedom of movement than it does with personal data in and of itself. Overall, looking at the big picture, the exchange here is very extensive and certainly the deepest outside of Switzerland and the EEA. And with that comes a commitment, importantly, to common, strong safeguards. And those safeguards both relate to standards and they relate to procedure. I'm not going to go through all of these, but the standards cover a whole suite of data protection provisions, accuracy, necessity, including over time, and of course security, including how to respond to data breaches. Procedurally, much of the exchange takes place through national contact points, although I should emphasise that this goes hand in hand with a strong emphasis on ensuring 24/7 access. DPA oversight, Data Protection Authority oversight, is of course there too. And in relation to PRUM data, there's provision for the Commission to conduct an audit or evaluation visit to look at those procedures and standards. The Commission has also very recently announced a draft decision to grant the UK adequacy status in relation to the Law Enforcement Directive. And if this goes through, the UK will be the first country to have such a status, and that will enable even more exchange in the area of justice and security. And I should emphasise that that adequacy agreement would go in as a complement to the provisions in the TCA on this sort of exchange. So overall, very extensive, but based on quite a high degree of harmonisation. Now let's turn to general data protection, and by general I mean the same sort of scope as is covered in the EU by the General Data Protection Regulation. Where is the understanding evolving here? Well, I argue that it's evolving towards a much looser arrangement based only on mutual adequacy. There were suggestions during some of the negotiations of going much further, including involving, say, the UK Data Protection Authority in the work of the European Data Protection Board formally moving forward, presumably based on a high degree of common norms as well. But that isn't where we seem to have ended up. Rather, as I say, it's only about mutual adequacy. So the UK has already granted all EA countries, including, of course, all EU countries, as well as the countries, quite a small number, which have been granted adequacy status by the EU, adequacy within its own new UK-only regime. And the EU has signalled that this is what it also intends to do. This wasn't in place by the time of the end of the transition period at the end of last year. And so there was a provision in the agreement which deems the UK not to be a third country, essentially to be part of the EEA, for up to half a year, so long as the UK makes no significant change to data protection. But that significantly comes to an end whenever an adequacy a decision has been made in relation to the UK. So that's clearly the goal. And in fact, the Commission, again very recently, has now produced a draft adequacy decision for the UK. And so if both of these things get set in place, we will be in a system of mutual adequacy. It's important to stress, though, that mutual adequacy is not the same as a kind of union or strong harmonisation between the UK and the EU on data protection. It doesn't provide for fully seamless free flow of personal data. It's not necessarily stable, as the US has found out, both in relation to Safe Harbour and then Privacy Shield in the Schrems litigations. It also, in many circumstances, comes with specific transparency requirements to let data subjects know of transfers, and documentation requirements as well. And of course, and importantly, it doesn't absolve controllers from potentially having to follow local law, and that will apply at least if they're targeting goods and services at the relevant market involving personal data processing. So unlike the old system where there would be only one law to follow, at least if it was the harmonised default of the GDPR, now in many circumstances, companies and other controllers will have to follow both EU law in addition to, say, following UK law in relation to certain processing and vice versa. And the fact that it doesn't apply fully seamless free flow is reflective of a second important feature, which is that it's not about an identity of protection or even an equivalence of protection, but even following the Schrems litigation, which did very much raise the bar on what adequacy means, it is only a system which is based on a recognition of essential equivalence between two, in principle, different frameworks. Now, whilst the Court of Justice has adopted quite a stringent approach to that, the European Commission still, I would say, takes quite a pragmatic approach to this issue, although that could change and could be changing. So its communication in 2017 on global data flow emphasised that there was no need for a point-to-point replication of the EU framework for a third country to be granted adequacy. But you would instead look at across the whole suite of that regime and assess it, as I say, based on its essence of equivalence. And it even mentioned some of the countries which had already been granted adequacy under the directive well before Schrems raised these thresholds, like Israel and New Zealand, which actually have very significantly different data protection frameworks to the EU. That's the case in general across both systems. For example, New Zealand has no concept of sensitive data within its law, but it may also be true, there are reports that it's very much true in relation to Israel as regards bulk surveillance, which of course has become such a big issue in the Schrems litigation. And so it's surprising that the Commission still reference these adequacy decisions. Of course, they may well be quite unstable given the evolving standards, but it does emphasise the greyness of these standards when it comes to adequacy compared to anything like full harmonisation. Another important point to mention is that the GDPR emphasises that the provisions in Convention 108, and we should now be thinking of Convention 108 plus the updated Council of Europe Data Protection Convention, as an important lodestar to whether essential equivalence has been achieved, at least, of course, when it's bona fide implemented, which may not always be the case. And so I'm going to use the Council of Europe Data Protection Convention as updated as a metric for looking at how the UK might have some flexibility and some discretion, because both systems, both EU and UK, remain strongly committed to this convention. And in many respects, this convention does set out the commonly agreed essence between these two frameworks or and other frameworks, as I say, as long as they are bona fide implemented. Okay, so now before turning to that, let's look at how the UK data protection framework has already evolved with Brexit. Well, so far it's only evolved at a quite formal level. The new regulations bringing Brexit after the transition into effect preserve the GDPR. They create a UK GDPR. They preserve the Data Protection Act 2018, which of course implemented the Law Enforcement Directive, as well as regulating other matters like pure national security processing. And the related e-privacy framework is also retained. The only differences, or the principal differences, are that the EU Charter right to data protection is not retained, which may give data protection a rather different flavour and status in the UK going forward. Though, of course, the European Economic Area countries don't, in principle, except insofar as it's recognised in secondary law, themselves recognise the EU Charter. Of course, regulatory cooperation and consistency, including through the European Data Protection Board, is not continued. I've already mentioned that and its importance. And the status of Court of Justice case law changes. Now, it's still binding current case law, unless it's overturned by the Court of Appeal or above. But nevertheless, it could be in the future. And of course, future case law is really only persuasive. So that is, over time, potentially of significance. But nevertheless, overall, the short-term framework is incredibly similar to the EU's framework. And of course, the two adequacy assessments by the Commission, which I went through, have been carried out on the basis of that very strong similarity. But nevertheless, that similarity may not prove fully stable. Strong proponents of Brexit, who are in the current UK government, like Michael Gove and John Whittingdale, have criticised the EU data protection framework, Gove arguing that it hobbles the development of internet companies, and Whittingdale making similar and more general remarks. And it's important to note that the TCA, while saying that both jurisdictions are committed to a high level of protection, preserves wide discretion in this area going forward. As I say, outside that crime and justice area, and to a limited extent also outside the area of direct marketing, it reaffirms the independent right of both jurisdictions to regulate privacy and data protection. So how might that independent right to regulate affect the UK framework in the medium term? Well, it may produce a degree of discretion, although I hope that that discretion will be exercised with a strong commitment to seeking to ensure mutual adequacy. So it's subject then to that adequacy boundary. The degree of change is unclear, both because that adequacy boundary is itself far from clear, and also because especially big business, whilst they might not like quite a lot of the detail in the GDPR, very much like consistency and being able to plan and organise across a broad jurisdictional area. So the lodestar in any analysis of discretion should be on mutual adequacy and bona fide implementation, as I say, closely linked are these two things, of the Data Protection Convention as updated. And a comparison between Convention 108 and the framework in the EU, I think, provides a good indication of what might be possible. I should stress, though, the more the UK departs from EU data protection, obviously the more controversial and difficult maintaining mutual adequacy will be. So the Convention 108 framework, when bona fide implemented, broadly conforms to other analyses of what essential equivalence might mean, and I refer in particular to the Article 29 Working Party referential on this topic. Okay, so what might a more Convention 108 plus approach compared to the GDPR look like? Well, there isn't time in this presentation to cover this across the board, but I just want to pick out a few areas of potential interest. So sensitive data is regulated somewhat differently in these two frameworks. Both adopt a categorical approach to sensitive data, including things like health, sex life, and religious belief. But Convention 108 importantly requires, in most cases, a sensitive purpose to be present as well. You look also at why the data is being processed, and is it being processed for that information which is revealed in the data being sensitive. And for that even applies in what could be considered super sensitive areas, particularly healthcare and sexual life. And so that would provide more flexibility in terms of when the sensitive data regime would apply. The other aspect to this is, of course, the rules on processing sensitive data, where again there's significant divergence. The GDPR is very much based on a default prohibition, which is only lifted in narrow and restricted circumstances, notably express consent, but sometimes also other things like a weighty public interest and safeguards. But a rule-based system, albeit a rule-based system that Court of Justice jurisprudence to an extent has departed from, when it comes to things like, well, when it comes to search engine indexing, see the GC et al. And Keneal case. But Convention 108 Plus is across the board more flexible. It just talks about a law with appropriate safeguards, presumably additional safeguards for this data. And again, that could enable much more discretion for the UK as to how it builds in additional protection for sensitive data going forward. Another critical area of potential divergence relates to the integrity provisions. For I'm sure very worthwhile reasons, and in theory motivated by concerns to produce greater accountability and perhaps, in a sense, more risk analysis by controllers. The GDPR includes a whole panoply of different integrity provisions for controllers and to an extent processors, which in Chapter 4 of the GDPR may not be considered to be particularly well suited to the whole scope of different operations which the GDPR regulate. In contrast, Convention 108 has a much narrower range of core. Of course, data security is always an important part of discipline or integrity, as is some form of accountability for ensuring compliance with the standards, and of course some system of export control. And the Convention also does contain some rules on responding to data breaches, at least going to the Data Protection Authority as regards very serious data breaches. But otherwise, it retains a flexible approach in terms of how you ensure that the controller is genuinely exercising due control over data, and that actually would enable a much more risk-based and flexible approach to be adopted within national law. So this contrasts quite strikingly with the large number of duties which exist in the GDPR, with data breach, of course, also notification to the subject and data subject, some documentation requirements, and also sometimes notification to the general public. A closed list of mechanisms for ensuring that international data transfers or data exports are managed appropriately. Very extensive rules on how you manage processes, processing on behalf of a controller or joint controller arrangements, and a whole suite of different accountability duties, maybe a requirement to appoint data protection officers, documentation requirements, extensive requirements for impact assessments, and sometimes even prior consultation with the DPA. So that kind of satellite area is certainly part of the GDPR, but is not necessarily part of adequacy. There is more flexibility in terms of how these duties could evolve going forward. And I could also talk about a similar flexibility as regards data protection supervision. Of course, data protection authorities are required in both systems, but the detail of the powers and the tasks also shows significant divergence. Although I should say that at a practical level, both, across the board, including within the EU, there are clearly major challenges on enforcement and supervision. That, of course, within the EU includes how the one-stop shop mechanism is working. And so I hope that there is some common agreement that we must ensure more effective and genuine supervision of data protection going forward. And so I'm not going to concentrate on that issue in this presentation. One issue which I do want to flag up, though, is whether there may also be the potential for deeper restrictions on that default. The default, as I say, may become somewhat more flexible, but also there may be some more flexible restrictions on the default, because the restrictions clause of Convention 108, I think found in Article 11, is wider than the GDPR, which is principally found in Article 23, I think. And so the UK could look, I suppose, at ensuring that some of the restrictions in the interest of things like the rights and freedoms of others, things like restrictions on transparency rules or some control rights, could be more subject to self-certification by controllers. There could be an analysis of whether a freedom of expression clause, which goes beyond special expressive purposes like journalism, literature, and art, and also academia, could be constructed. I say these two things because they are actually elements which potentially not within the GDPR's framework, but nevertheless have been adopted by even some EU member states, but not by the UK so far. But there could also be the potential for a more far-reaching limitation on that default, as Sweden, in fact, did under the directive, again with an unclear relationship with EU law when it's about full equivalence, but adequacy is not that, where in low-risk areas there was a shift from a sort of rule-based system to a focus on whether the data is being misused, and this particularly related to free-flowing texts, which of course are very ubiquitous in terms of including personal data, with Swedish law now repealed, of course, because the GDPR applies, saying that if the data isn't structured to facilitate search or compilation, then you don't follow the rules unless you show that there is a risk to privacy or integrity of the data subject being violated by these arguably low-risk activities. So I'm not saying that the UK will choose to adopt these more flexible restrictions. I'm just pointing out that these restrictions become possible whilst maintaining adequacy, or at least potentially possible whilst maintaining adequacy, in a way that they weren't really possible whilst maintaining good compliance with the GDPR whilst the UK was within the EU. Okay, so a few conclusions then. I hope I've shown that the UK does have, now under the TCA and these hopefully coming adequacy agreements, a close data protection relationship with the EU, the closest, in fact, outside the EEA and Switzerland. But I want to come back to this Swiss example because, you could point out that Switzerland hasn't pushed for law enforcement directive adequacy, and it doesn't even have a passenger name record agreement for the exchange of flight data with the EU either. That could suggest that the UK relationship with the EU on data protection is stronger than the Swiss relationship. But I think that the reason why Switzerland hasn't pushed for something like a PNR agreement is because there are actually very strong data protection norms and privacy norms in Switzerland, such that there is no demand for this kind of exchange, at least so far. There may be in the future, within Swiss politics itself. And that points to the fact that data protection norms within Switzerland are much closer, as I say, to a EU norm, which of course places a strong value on data protection, than at least some parts of UK politics, which have been more sceptical about the EU's approach, including some of the bureaucracy and red tape, which arguably goes alongside some of the EU's approach. So if that's right, then maybe the UK won't fully become another Switzerland. Hopefully, any relationship moving forward will still be very much based on mutual adequacy and working together in the Council of Europe within the framework of the updated Data Protection Convention. But I think we may well see in the medium term the UK pulling away more from EU data protection with some divergence, potentially some tricky tensions, but hopefully still ensuring mutual adequacy, as I say, and the Data Protection Convention. All these thoughts remain extremely tentative. We're only into the first few months of really living with Brexit, but I hope that they are still interesting and add to these conferences' proceedings. So thank you very much for your attention.